Hello everyone, it's Wayne Jones, the course coordinator for statutory interpretation. We're looking at the material from week 3, which is covered in the textbook by Michelle Sanson, Statutory Interpretation. And as usual, I just want to give you some my own comments about what I think you need to definitely take away from Chapter 3 after you've had a read. I guess where we've just been is to talk about some of the initial concepts around where statutes fit, say, with respect to the common law. And Chapter 3 reinforces again that the Parliament remains sovereign over the common law. And so consequently, after decades, if you like, or hundreds of years even, of the courts interpreting legislation on behalf of the legislature, the various legislatures themselves decided that they needed to get into the arena, and so they passed their own statutory interpretation laws. So there are in Australia both Commonwealth and state and territory interpretation laws. And we'll look at some of them in a moment, but they're usually styled something like Acts Interpretation Act or Legislation Act, something like that, or the Interpretation of Legislation Act. There is a Commonwealth Acts Interpretation Act. So what you've got there is you've got the Parliament saying, well, we're making the legislation and now we're going to actually legislate and put into an act how it is that we want the courts to look at the legislation we make. So the laws of Parliament prevail over the common law, particularly where there are common law rules regarding statutory interpretation. We'll talk about some examples in a minute. And this includes any common law rules that have been made about statutory interpretation. But I think most importantly, the textbook authors make this point at the outset, and don't go past this. The fact remains, though, that even the Acts Interpretation Act is still an act that needs to be interpreted by the courts. And we'll see some good examples of that in a moment with respect to words like may and shall. So you'll see where the interpretation legislation tells the courts how they should look at those words, and then the courts will still, though, apply various rules of statutory interpretation. But 2 points. Once the Parliament passed the legislation, it couldn't interfere with the way the courts would even use that interpretation legislation. And another important point, again made in the textbook, is it doesn't mean that cases which were determined in a particular way can somehow be unwound and revisited if the interpretation legislation gives a different view of the world afterwards. All right. Another quick point, be aware, of course, that interpretation legislation applies not only to acts of Parliament but also to delegated legislation. And another point, there are various acts. Be aware that the Acts Interpretation Act, the Commonwealth one, applies only to Commonwealth laws. So you wouldn't use that act, for example, to interpret state laws. In fact, there are a whole list of state acts that you can refer to. And what I would like you to do is to have a look at the Acts Interpretation legislation in your own state. You'll see, and again the textbook authors make this comment, you'll see that there's some commonality between them. Some things are different, some little funny quirky things, for example, in relation to the measurement of distance in Queensland. That's done slightly differently. And some use slight variations of the words, but all of the states, territories and the Commonwealth are all trying to achieve the same sort of thing. And there are a couple of functions. One is to try and simplify acts, and you'll see things like a movement towards providing an overview and a simplification at the beginning of the legislation, and here is an example of that. The second is that using some standard definitions is something that's not unknown, for example, in commercial law or in contracts, in leases, etc. And if you can set a benchmark somewhere, and that somewhere is in the interpretation legislation, and define the meaning and the effect of some common terms that appear in legislation and some common concepts in the same way that a dictionary does, then you can help shorten the legislation. So that's where you'll see things like, unless expressed to the contrary, the following applies to all Commonwealth legislation, and you'll see examples of that in the Interpretation Act. And of course, the other function, which we don't deal with in Chapter 3, I think the authors deal with this subsequently, is that the legislation states the general rule of statutory interpretation, if you like, the where we've got to with statutory interpretation in recent times, and that is the legislature expects the courts to look at the object and purpose of the Act and try and give its legislation an effect which will further that object or that purpose. And that's why I got you to think about that. You'll think about that sort of stuff, and we'll look at it again in future weeks. So object and purpose. And it also gives permission for courts to look at extrinsic materials, and that specifically means things that are outside of the Act. And you've already thought about some of those when I've said to you, have a look and see if you can find explanatory memorandum that went in with the original bill, and maybe reading speeches from Parliament where there's an explanation given. So that's the second limb to why you have interpretation legislation, stating some general rules about interpretation, looking at object, looking at purpose, and giving permission to look at extrinsic material. Now, I'm going to suggest that you just be familiar with the fact that in line with that first purpose, there are some fairly generic terms that are covered, and the textbook gives a mention to those. Gender, age, number, distance, they're all covered in the interpretation legislation. And just to pick one, the first of those, gender. Section 23A of the Commonwealth Act simply says that words importing a gender include every other gender. And in fact, if you go on and do any commercial law, you'll see that there's usually a boilerplate clause in most contracts and agreements that'll say something like that these days. It's just seen as it's worth stating in a contract, it's worth stating in a commercial document, and so certainly it's worth stating in respect to legislation. Have a look at what the textbook authors say about distance, for example. Queensland's got that quirky thing about how distance is measured by the shortest road unless the legislation says you do it differently. Most other places say, look, it's as the crow flies, but just have a look at that one for yourself. The one that I think you do need to, and of course, as I've just mentioned, using an index, using a dictionary at the beginning of a document, providing standard definitions used all the time in many legal documents. The one I think you need to take particular care over is this one about time. So do have a close look at what the authors have to say about time. The legislation is pretty specific in most of the states and in the Commonwealth. It says when you're talking about time, it's whatever the time is in that place. It sounds a bit obvious, but it's comforting to know that at least it's in the legislation. So if it's Eastern summertime in a particular state, that's the time. So, and just as importantly, look at the comments about trying to work out how many days you've got to do something in a piece of legislation. I've said it before, if you take nothing away from this interpretation course in 2 or 3 months after it's finished, other than to remember that there's some very specific rules about measuring time from a date to another date. We're talking about things like legislation that tells you must file a document within 30 days, or you must file a document within a month. Be aware that you should go straight to your interpretation legislation in your state, if it's a state act, or straight to your Commonwealth legislation, if it's a Commonwealth one, and just check and see what your local legislation says. And here's a couple of examples. At generally meaning 1 second past midnight on that particular day, and from excluding the nominated day. So if you need to do something from a certain date, it doesn't within 30 days from a certain date, it excludes that nominated date, it starts the next day. And just to make it a little easier, Section 36(1 of the Commonwealth Act, for example, not only lays it out in a column that talks about, well, let's look at the first one there. If the period of time is expressed to occur between 2 days, then column 2 tells us, then the period of time includes both of those days. So you just work down that column and you'd find one that fits. But as I said, if you do nothing else, whatever you do need to do is go away from this course knowing that there is some assistance for you when you have to work out fairly strict time limits. Because remember, sometimes you can end up being sued by your own client if you get a time limit wrong. And certainly, on a happier note, you want to help your client to get something done within the time limits that's set by the legislation. Now, the next big ticket issue for me in Chapter 3 is this business around may and shall. Look, the good news is it's going to come up again. It'll certainly come up in administrative law if any of you take administrative law. But it's an argument to be made, and it mainly is about government action, so hence administrative law. So what did the legislature itself say? Well, it said this, that here's the Commonwealth example, if an act provides that a person or a court or some other body may do a particular thing, and the word may is used, the act or the thing may be done at the discretion of that person or that court or that body. Now that's a pretty important thing, because that's normally as you understand it, isn't it? May seems to suggest, well, you know, they may do it, they could do it if they wished, they have a discretion to do it, whereas shall would tend to indicate that no choice, really do need to do it. So what the legislature has done is it's offered up this general rule where an act assented to after the commencement of this act says that you may do something, then it can be done at the person's discretion. Now, that's fine until we have a look at how the courts have approached that over a period of time. So what they have done, what the courts have done, is to look at that and come up with a general proposition which is probably best stated in the Project Blue Sky case, and that is to say that the whole may and shall thing doesn't really, isn't really the last word. The view that the courts have taken is to say, okay, we've got to take notice of the interpretation legislation, but we have to also be convinced that when something happens or doesn't happen, that looks like it should have happened, might be a shall instead of a may, we still need to be convinced whether it was a purpose of the legislation that if there's a breach, the whole thing should be invalid. So I won't bore you with the details of those particular cases. Project Blue Sky, there's a nice little extract, not only in this chapter but in a subsequent chapter. It's quite a seminal case in statutory interpretation. But for our purposes for Chapter 3, I think you just need to be aware that even providing a definition for may and shall in the interpretation legislation, the courts still will have a closer look at whether or not doing the particular thing should in fact lead to an invalidity. Also note that in that whole may and shall argument, the courts are looking at questions, for example, around what happens if the legislation requires something to be done and it's not done at all, so that it's just ignored. And that's probably the case in the Animals Angels case, where the people who were advocating on behalf of the animals were saying, well, there was a reasonable expectation that, well, they thought that the minister would act when a whole lot of terms of a live export licence was simply being breached by the exporter. Even though the word may was used, their argument was, well, it almost seems mandatory that if the exporter behaves really badly, that a show cause notice should issue saying, well, I want to cancel your licence. And in fact, the court didn't agree with that. They came back and said, oh, you've got to look at all of the circumstances. And you'll hear more about that as we progress through the course. This issue around, really you've got to look at all of the surrounding circumstances. In subsequent weeks, we talk about, in interpretive techniques, etc., about context. So what's the whole context? So sure enough, there were lots of breaches to the licence, but for example, the court came back and said, well, what if it was a contravention of a licence condition, but it was a pretty minor one? Are you saying that we have to tell the minister that it's mandatory that he needs to exercise a discretion? So that was the question around where something's done or not done at all. But also note that may and shall applies in circumstances around whether something's been done when a discretion is given. Has it been exercised reasonably? And you look at that in a lot more detail in administrative law. But essentially what they're saying there is, if a discretionary power is given by statute, then there's an assumption that if the person who has the power decides they will exercise it, then it'll be done reasonably. And any use of the discretion that's so unreasonable that no reasonable decision maker could have come to the same conclusion is likely to be invalid. So it's a sort of a fairly complex argument, and certainly one for a later day in administrative law. But again, for the purpose of Chapter 3, just be aware, may and shall, the courts are still coming up with other interpretations. And the final one is this one about process and procedure. If an act prescribes a particular form and that's not complied with, does that make everything invalid? And the textbook authors take you to Section 25C in the Commonwealth Act that essentially says when an act talks about a prescribed form of doing something, strict compliance isn't really required, and substantial compliance is usually sufficient. And you see that a lot, for example, in anything to do with employment law. So not so much for straight-out legislation, although legislation in the Fair Work Act refers to certain processes and procedures that need to happen, but in policy as well. So if an act says a process should be followed, the starting point from the Commonwealth interpretation legislation is, look, substantial compliance is usually going to be sufficient. Just something about the commencement of acts. Look, I'll let you read through that in your own time, but simply be aware that from state to state, for whatever reason, and including Commonwealth and state to state, there's a variety of different ways that each of the states work out when things start. So we know from previous week's reading that a bill passes through Parliament, gets voted on, and then it goes to the Governor General for the royal assent. Now, from that point, at the Commonwealth, in the Commonwealth, the Act will come into to effect 28 days later, and it's different times for different states. And really, I won't say any more other than that, because I think all you need to do is, if you're dealing with something that's relatively close to the date that the law has come in, you might want to have a look and just see whether it was actually in effect at the time that the law was actually validly in effect at the time that the thing happened. You know, the accident, the incident, the alleged breach, etc. You do need to have a good look at the cases and the examples that are given with respect to amendment. The authors make a comment about whether something is a consolidation or a reprint. Look, there's really not much in that. I think the main thing that you need to be aware of is the first thing, I suppose, is that when an amendment happens, it takes effect from that date forward. So think about that. Let's pick something out of the blue, like Maxwell and Murphy was probably not a bad example, but if let's say that there was a power to bring an action right up until the 1st of July this year, and then an amendment happened which took that away. That amendment only takes effect from the 1st of July forward. So anything that happened before that, that law is still out there. That law is still out there. That's why there's preoccupation, if you like, with time. You know, the fact that you do need to work out when something did happen. So that's the big issue with respect to amendments, to be aware that the law is the law up until the 1st of July, then there's an amendment, and then there's the new law. But it doesn't mean that the old law has disappeared. Any rights that accrued before that still exist. And the only exception to that, the only exception about that and about something acting in a retrospective way relates to whether something is just procedural law. And look, the best example that I can give you with respect to the difference between a substantive law and a procedural one is probably this Maxwell and Murphy, where they said if a right had been extinguished prior to the amendment, then making an amendment which in the Maxwell and Murphy case extended the amount of time that the widow could have made a claim for compensation, it was just too late because the previous law had applied and that right had expired. Now the new law going forward, of course, would give people 6 years in which to make a claim. But the poor old claimant in that case, she was stuck with the law as it was previously, and her rights under that law had expired. Now the procedure, the substantive law, that's the substantive law. It's something that just dealt with a right, actual substantive right or a liability. Amendments which just deal with the pursuit of the remedies are things like the proceedings. Again, just to make up an example, an amendment which, say, required that an application be made in a particular form. For example, you had to use a certain form, or perhaps even an amendment that said, this is an example from recent times, where you used to be able to bring a claim in QCAT, but now you have to bring it in the Federal Magistrates Court. Those sorts of procedural amendments, the how to make the case happen, they apply even in cases where your right or your remedy was accrued beforehand. So to use that Maxwell and Murphy case as the example, so, say the client was, the big issue was not that they'd missed the time limit, but which court to bring their claim in. Even if under the previous law they used to be able to bring their claim in QCAT, the new law came along and said you must now bring your claim in the Federal Circuit Court. They've got to use the new law because it's not about the substantive rights or liabilities. It's just about process and procedure. So look, worth noting that. Have a read of the case for yourself to get a better grip on it. Repeal is pretty much in that same sort of paddock, really. Parliament can make laws, so consequently they can amend them and they can even repeal them, take them away. But repeal is not from the beginning, only from the date that the Repealing Act comes into force. So same sort of thing, same sort of rule applies as with amendment. A repeal, if once a law is repealed, it's over. It's off the statute books now. But if you had a right which accrued before the repeal, and you were perhaps in the middle of a court case about that right that you had, you might have been suing for something or other back then, no one in the future will be able to make a similar claim that your claim is still fine. You can continue to pursue it. And look, note those comments about repeal of a repealing act. So let's use that same example again. You had a right to make a claim about something or other. That legislation then was repealed, and then subsequently that repealing act was repealed, which, by the way, I'd have to say is a fairly rare thing. But theoretically, this is a bit theoretical now, it doesn't revive that earlier act. But note the comments in the textbook, though, if the act, which is if the first act was something that substantially changed the common law, Again, I'll give you an example. Say you had a right to make a claim for fishing rights somewhere or other under some old common law, and then that was regulated by a new statute which came in. And after a year, people just thought, oh, that's horrible, it's not working, we hate this new regulatory statute, so it gets repealed. What you go back to is the old common law. It does revive. It does come back again. Here is the section that you need to have a quick look at from the Commonwealth Act, similar sorts of sections in other legislation. So the repeal of an act or part of an act that repealed an old act doesn't revive the old. So that's what we just talked about. Where an act contains a reference to a short title act that was provided by law for the citation. Look, complicated wording in this. Essentially what section 10 means is that if an act referred, I'll make one up, shall I? If a piece of legislation that you're looking at refers to, say, the Queensland Judicature Act of 1856. So your act refers to that older act, and that's the short title, the Queensland Judicature Act of 1856. If that other act changes, then the reference shall be construed as a reference to that other act, either as originally enacted, the Queensland Judicature Act of 1856 or whatever, or as amended from time to time. So really, that's just a business provision that says you don't have to, the Parliament doesn't have to be constantly scanning its legislation to make sure, oh, well, look, if I change the name of that act or I change it in some modest way, I'll have to change every other act on the statute books that might refer to it. That's all it is. There's not much to it, but just be aware that they've got that flexibility. And then finally, towards the end of the Chapter 3 textbook, it refers to the fact that sometimes a piece of legislation might be found to be invalid. I think the best advice I can give you there is to have a look at the two cases, Roach and the Electoral Commission, and have a look at the Australian National Airways case. They're good illustrations of how this works. In contracts and in contract law, you do talk about whether you can sever a particular section so that the rest of it can still work. Can the court still give effect to the contract if you took out a clause that was a bit offensive? It might be a clause, for example, that had a restraint of trade in it, but the rest of the contract works okay. That's a fairly common one that is excised from contracts when the courts get involved. If it can be severed, and the same sort of rules apply to legislation. So if the courts can still give effect to the legislation, taking out the offending section, they'll do so, and it can continue to operate. But if you take out that particular provision, and either one of two things happen: either the Act works in a really different way, so the courts look at it and say, this could not have been what the legislature intended. Without that section, the whole thing just falls apart. Or if it just doesn't work at all without that section, then if a part of the Act is found to be invalid, then in that case the whole Act can fall over in a heap. But you really need to have a look at the examples, and they're good one in Phillips, the Australian National Airways case, and Roach and the Electoral Commission. Have a look and see what you make of those. But yeah, quite an interesting little section, and I think you do need to keep an eye on this. Get your head around those may and shall. That was a big ticket item, and then just make a note for yourself about what happens when something's amended. Okay, well it applies from that time forward, not retrospective unless it's just a doing clause, a doing condition, a doing section in the Act. You know, one that relates to how you prosecute your claim, for example. What happens with repeals, and what happens when a section is found to be invalid, and just make a note of what happens in those situations. And the big one, as I said before, was make a note about what happens with time. At least remember that there is a section in the Commonwealth and and in most of the state legislation that explains to you how you're going to work out time limits. Okay, thanks very much. We'll talk again soon.